Go on the record in the matters 24 CF 170, 24 CT.
All right, here we go, another day, another courtroom surprise. From the very first few seconds, we're hit with something major. A plea agreement might not be as clean as it looks. Imagine walking into court thinking everything's finalized, only to realize a key part of your deal was never even agreed upon properly. Stay with me, this one's layered.
3-3. State of Wisconsin versus Jacob Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones in person, in custody, with counsel Gabriel Pollock. We're set here today in these matters for two things. First is with regards to 24 CT 3-3, the OWI third was inadvertently dismissed and read in with the agreement, and I do not believe that was part of the agreement. Is that correct, Mr. Pollock?
Your Honor, I guess I'd spoken to Ms. Rockow earlier this morning, and we had just noted that it had been read in and believed we were here for sentencing in the 24 CF 170 matter.
No.
Understood, Your Honor. I can certainly conference with Ms. Rockow to see how she would like to proceed with that. I guess I'm not sure how the court would prefer to proceed.
Because the OWI third was not a part of the agreement to be dismissed and read in particular because the legislature, as well as the public and the public interest, looks at those matters, the OWIs, very, very seriously.
This is a big deal. The judge is rightfully pointing out that OWI are operating while not a throwaway charge. It carries serious implications for public safety, especially on a third offense. And here's the legal kicker. If the court had known this part of the deal was missing, they likely wouldn't have approved it in the first place. That's how fragile and serious plea agreements can be.
And that was overlooked by all parties, including the court, when all the multiple cases and multiple things were put on during the plea hearing. So with regards to 24 CT 3-3, that matter, the court does not allow that matter to be dismissed and read in. And if that affects today and what's going to happen today, then we need to address that, and this matter needs to be reset because, again, the OWI third.
Let me ask you, whose responsibility is it to catch mistakes like this in a plea deal? Should it be the defense attorney, the prosecutor, or is it on the judge? Drop your thoughts below, because someone clearly dropped the ball here.
In 24 CT 3-3 was not a part of the agreement that was reached between the parties, and that was not the agreement that was recited to the court. If that was recited to the court would not have permitted the agreement and would have proceeded to trial.
Understood, Your Honor. I believe that Ms. Rockow and I can likely come to an arrangement. I just had not done that at the moment, but I think we can likely have that figured out.
All right. So why don't you go conference with Ms. Rockow, and then you're going to need to conference with Mr. Jones because I don't want him to feel rushed, but this matter can all be reset to a different date and time. However, I do understand that this is your last day on at the public defender's office in this capacity.
Now things are getting tricky. The public defender is about to leave his position. Supporters are sitting in court expecting closure, and the whole agreement might be delayed. We're watching a high-wire act with lives, timing, and reputation all hanging in the balance.
And another public defender would need to be retained or appointed.
Yes, Your Honor, I appreciate that. I also know that there are numerous people here in support of Mr. Jones, so if we can accommodate this, that would be my preference.
All right, we will briefly adjourn.
Your Honor, I have completed the plea questionnaire, if I may approach.
Back on the record, same appearances as previously noted. The parties have reached an agreement. Mr. Pollock has went over a plea questionnaire waiver of rights form as it relates to 24 CT 3-3, operating a motor vehicle while intoxicated. Mr. Pollock, can you please recite the agreement on the record after the court is making the formal order to reopen 24 CT 3-3, because that was not a part of the original, that was not a part of the agreement, correct, Ms. Ms. Rockow?
Correct.
And correct, Mr. Pollack?
Yes, Your Honor.
All right, please recite the agreement for the record.
Your Honor, our understanding of the agreement, if Mr. Jones enters a
So slowly.
Yes, Your Honor. Our understanding of the agreement is if Mr. Jones enters a plea of guilty to count 1 in 24 CT 33, which I believe is the operating while under the influence of an intoxicant, count 2 and 3 would be dismissed count 3 would be dismissed and read in, count 2 would be dismissed by operation of law, or nope, count 2 is not operating while revoked. I thought there was a prohibited alcohol concentrate. So the remaining counts would be dismissed and read in, 1 as a matter of law. The parties would join in recommending a sentence of 45 days in the county jail, a fine including
What did the defense attorney just toss out numbers and penalties like they were improv lines? The judge is clearly not amused. When you're recommending jail time and fines, you better back it up with actual sentencing guidelines. This isn't a courtroom buffet, too. Don't just pick what sounds good.
various surcharges of $1,844, loss of operating privileges, and requirement for an ignition interlock device for 24 months.
Where are you coming up with those things? You're just kind of pulling them out of the air?
Your Honor, I think a lot of this was
That's not even my IDIP guidelines, which is the lowest, and that's not even the district guidelines.
Your Honor, I guess
Your Honor, I think that we're now viewing these as this is now kind of a global situation that we have here. We're resolving the felony file and the CT file together. The 45 days is the statutory minimum period. I think that's appropriate given the recommendations the parties will be making for the felony. We are recommending a lengthy period of supervision. So I think that's appropriate given that level of protection to the public. Also, I understand that Mr. Jones spent 12 months in the county jail or was sentenced to 12 months in the county jail due to the revocation. So I think that we can also factor that in terms of what's best for the public. The other thing is that there was an IDIP recommendation or offer that was made, of course. He had begun doing that process, as I understand it, according to my file at least. And then, of course, he was incarcerated. We're coming up with the 45 days because that's the statutory minimum.
Okay, what about the 1844, the 1,844? That's
What's happening? Now is a classic case of legal confusion, different guideline grids, different dates, and mixed up fines. One side says it's $1,844 based on 2023. The judge points out 2024's guidelines say it's higher. This kind of back shows just how precise you have to be in criminal sentencing.
That's just a random number.
That's the 10th District guidelines for this offense date from the 2023 grid.
But this occurred in July 2024. My July 2024 grid is 1869.
the OWI was February of 2024. I don't think that the guidelines had gone into effect at that point.
Right.
You're right. I was looking at the burglary.
Correct.
That is correct.
So the state has no objection to the minimum fine.
All right. Okay. Now we're making sense. All right. Okay. So that's the agreement that's been reached, Mr. Jones.
If you're still with us through that maze of numbers, charges, and statute references, you've officially earned your honorary law degree. Give yourself a pat on the back and maybe drop a comment. Would you trust your lawyer if they couldn't clearly explain the deal?
Yes, Your Honor.
And I have in front of me the plea questionnaire waiver of rights form as well as the jury instructions. Did your attorney go over this with you?
Yes, Your Honor.
Did he go over it thoroughly with you?
Yes, Your Honor.
Essentially word for word?
Yes, Your Honor.
And you understand everything contained on these documents?
Yes, Your Honor.
And is that your signature on the second page of the plea questionnaire?
Yes, it is.
Do you understand that you're pleading guilty to an OWI third offense?
Yes, I do.
You're 24 years old. You have 12 years of schooling. You can read, write, and you understand the English language.
Yes.
You are receiving treatment for a mental illness or disorder, and you are taking medications. What is that mental illness or disorder?
Anxiety and depression.
And are you taking medications for those two particular disorders?
Yes.
And what are the medications?
Sertraline.
And you take that as prescribed?
Yes.
Does that interfere with your ability to comprehend or understand what's going on?
No, Your Honor.
Does it actually help you a little bit better?
Yes.
Okay. Now, other than that, no alcohol, medications, or drugs?
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, he did.
So you understand those rights completely?
Yes.
Do you understand that by pleading guilty, you would be waiving and giving up those rights?
Yes, Your Honor.
Do I need to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you also understand that there is a recommendation for the court to follow the lowest guidelines as it relates to the jail and the lowest monetary guidelines for the lowest jail, the mandatory minimum jail for the jail time, as well as for the court to follow the district guidelines for the fines and penalties? Do you understand that I wouldn't be bound to follow that recommendation?
Yes.
And do you understand here the state would have to prove on or around February 18th, 2024, that while operating a motor vehicle on a highway or roadway of this county and state, that you were under the influence of an intoxicant, and this would be counted as your third offense. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of less than $600, but no more than $2,000, or you can be imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, Your Honor.
And again, do you understand that I'm not bound to follow the recommendations? I could sentence you all the way up to the maximum possible penalties.
This is the moment that makes or breaks everything. Third offense, OWI. The defendant is pleading guilty and he's staring down the barrel of a potential 1-year jail sentence. One bad decision, repeated over time, and now it's catching up to him in full force.
If I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, did you go over the criminal complaint, that original charging document with your attorney, which pretty much says what happened that day and why you were charged with the crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
Yes, Your Honor.
Mr. Pollack, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today
Yes, I am.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes, he has.
Has he discussed with you a possibility of any defenses you could have if this matter would go to trial?
Yes, he has.
And has he discussed a possible lack of defenses you could have?
Yes, Your Honor.
And so you're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, operating a motor vehicle while under the influence, a third offense, how do you wish to plead?
Guilty, Your Honor.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up the rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 24 CT 33. Count 2 and 3 will be dismissed and read in for purposes of sentencing. Count 4 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Now we're going to move on to sentencing, and we will in fact do a dual sentencing in this matter. We have the sentencing for the operating while intoxicated third offense, and we do have the sentencing in the 24 CF 170 matter in which you did plead guilty to 1 count of strangulation, suffocation, 1 count of false imprisonment, and 1 count of stalking. They are all felonies. The court ordered a pre-sentence investigation report. The court has reviewed that report thoroughly. I have also received and reviewed the sentencing memorandum for...
Oh, and just like that, we shift gears. We're no longer just talking about drunk driving, we're now dealing with felonies, strangulation, stalking, false imprisonment. These are serious, violent offenses. The courtroom just got 10 shades darker.
Jacob Jones, filed by the Public Defender's Office. And I believe there were other letters here or there filed on your behalf from your counsel that I have reviewed as well. Ms. Rockow, have you received a copy of all of those documents, but in particular the pre-sentence investigation report?
I have.
And have you reviewed that report? And in your review, did you find any material facts or other information that needs to be corrected on the record?
No, Your Honor. Thank you.
Mr. Pollack, did you receive and review that report?
Yes, Your Honor.
Did you find any material facts or other information that needs to be stated on the record?
Just, I guess, a supplement. There was in the Vocation and Education and Employment section some discussion of working at Gary's Cafe in Siren, but no dates provided. Mr. Jones advised that he worked there from February of 2024 until July of 2024. There's also a description of him working at a car dealership. He advised that was Luther Autos Hyundai in Bloomington from March 2023 until September 2023. Other than that, nothing else.
All right, thank you. Okay. Ms. Bauer, Victim Witness Coordinator, are we going to have any victim impact statement? No, Your Honor. And in my review of the case, I did not find any impact statement filed in this case. Is that correct?
Yes, Your Honor.
The only information that I have received from the victim would be the information contained in, I believe, in the complaint.
Yes, Your Honor.
Okay, all right. Ms. Rockow, argument and sentencing recommendation, please.
Thank you, Your Honor. The state has considered the material in the PSI, and of course, all of the facts and evidence in this case very carefully, and is joining the defense in a recommendation to the court for an imposed but stayed prison sentence. Specifically, the state is recommending that Mr. Jones be sentenced to an imposed but stayed sentence of, as to count 3, 2 years of initial confinement, 2 years of extended supervision, as to count 6, imposed and stayed 2 years initial confinement, 2 years extended supervision, and as to count 7, imposed and stayed 1.5 years initial confinement, 2 years extended supervision, all to run concurrent to each other, as this was one incident. I think that it's appropriate that they do run concurrently. The state recommends a period of 4 years of supervision. The state also recommends the court adopt the conditions that were outlined in the PSI recommendation for conditions of supervision. And as to the OWI, the state asked the court to adopt the joint recommendation for the 45 days of mandatory minimum confinement in jail. I believe that that's sufficient, as I stated, based upon the recommendation the state is making for the felony convictions. This, of course, we have to consider the Galleon factors, and we have to consider probation first. The facts of this case are very, very serious. There's no denying that. That is of utmost importance when the state makes a recommendation in a case such as this, and what will be best in terms of keeping the public safe. In reviewing Mr. Jones' history.
Now here's the dilemma. The prosecution says, yes, these are serious charges, but this guy might benefit more from probation than prison. That's where the galleon factors come in. Wisconsin law requires courts to consider rehabilitation and public safety before jumping straight to incarceration. Is probation a second chance or a risky bet?
He does not have a violent history. He has a history that looks like somebody who uses alcohol and makes bad choices when he uses alcohol. He is fairly young. And I think as evidenced by his criminal history and by what was outlined in the PSI and the facts of this case, he has a lot of rehabilitative needs. But the state disagrees that there is an obvious pattern of serious conduct that the defendant has engaged in, which was mentioned in the PSI. The only pattern that I see is that he has multiple OWI convictions. So that suggests a pattern of substance use. In considering probation first, I think that based on his record and based on his rehabilitative needs, the safest thing for the community is to indeed rehabilitate Mr. Jones within the community. I believe that probation can adequately supervise Mr. Jones within the community and do that in a way that will protect the community, that will protect the victim as well. I think that based on his record, based on his age, we're not at this stage yet where the state's position is he should go to prison for a lengthy period of time or at all. But certainly he has a significant amount of prison time in the imposed in-state recommendation hanging over his head should he fail on probation. Probation will give him the tools that he needs to manage his sobriety and to manage any other issues that he has with criminogenic needs, such that he can maintain a life where he's contributing to the community. If the court sentences Mr. Jones to prison, I don't know what rehabilitative programming he'll engage in, but I think that it will impact his life in such a way that upon release, maybe he's not as engaged in, or not as able to be engaged in work and community programming. If the court places him on supervision, he'll have those stability factors put in place right away. He'll have to engage in day-to-day real life.
What about 22 CF 012? And now there is a material fact that I have just discovered because DOC put it as 22 CF 212. Yes, it was dismissed and read into other cases, but there is a very similar fact pattern that was charged out by the district attorney's office. Very, very similar. Where we have there were allegations of strangulation, suffocation, battery, disorderly conduct. Perhaps that's where we're getting the pattern from the DOC agent.
And I agree with Your Honor. I think that is the pattern that's the only pattern that they could be pointing to. My concern in using that as a basis for a pattern is that it was dismissed. It's a dismissed case. I don't know.
Then why was it charged by the district attorney's office? And we have the facts in that criminal complaint.
This right here might shock you. Even dismissed charges that never led to conviction can still be used by the judge at sentencing. It's called a read-in, and it gives the court leeway to consider patterns of behavior, not just proven convictions. It's controversial. It's powerful, and in this case, it might be the tipping.
Dismissed but read-in charges, are the court's able to view those and use those for sentencing purposes, not only for restitution, for sentencing purposes. And for whatever reason, back when he pled out in those cases, that was the deal then. It can't be overlooked.
It can't be overlooked. I agree with that, Your Honor. And I wasn't in this office in 2022, so I don't know. But I can say that it's not my practice to.
So now we ask the bigger question. Should a person be judged for something the court technically dismissed? Is that justice, or is it stacking the deck unfairly? This is the legal gray area that most people never even hear about. Let us know in the comments, was this fair, or did the system overreach?
Dismiss a case that serious unless there were some issues with the case itself and issues with proving that case. I don't know the facts and circumstances surrounding the dismissal of that case, but it looks to me like it was dismissed in favor of bail jumps. And so
bail jumps look better on a criminal record for a criminal than does strangulation, suffocation, perhaps. That's why you wheel and deal.
Of course.
Doesn't mean the facts didn't happen. That's why you wheel and deal.
Right. And agreeing, to have something dismissed and read in also means that the state can't bring those charges again.
Except in another case like this.
So I don't know the particulars of that dismissal is what I'm saying, Your Honor. But